Please call the roll. Answer the roll, please.
Mr.
Yes, sir.
Mr. Chair, you have a quorum.
Thank you so much. Thank you, Rose. 14-0. Thank you so much. I believe a couple of have to leave. What we want to do is first to have the subcommittee meeting. Now, those of you that have a phone, please put your phone on silence, please. Please. At the advice of my lawyer, my two lawyers, they told me to say that. So please, put your phone on silence, please. Thank you so much. We have two colleagues that have to leave and come back. So because that, we're going to take up what bills that we can. So we're going to start off with the subcommittee reports. Senator.
Thank you, Mr. Chairman. Subcommittee number 1 met last week after full committee. We acted on 1, 2, 3, 4, 5, 6, 7, 8 bills. Senator McClellan here, and she leave?
No, she leave. Skip her.
Okay, we're going to skip Senator McClellan's bill until she comes back. And then we're going to skip. Oh no, we can do my bill. So Senate Bill 1431 was my legislation relating to the removal of elected officials by the courts. The bill was a Boyd Gray's recommendation, and actually, you know what? Why don't we hold off on that until Jen comes back, because we didn't make a recommendation on these two for a reason. I can explain them both at the same time. So next up, Mr. Chairman, we have Joint Resolution 223, which is Senator Locke's resolution, which is a constitutional amendment to amend the Constitution to confirm every Virginian has the right to vote. It basically says that everybody will have the right to vote unless they're currently incarcerated in a prison. You saw this legislation last year. The subcommittee recommended reporting 3-1, and I would so move.
Thank you, Mr. Chairman. The proper motion second that we report SJ 323. Anyone to speak?
223.
223, thank you. Anyone to speak for the bill?
If anyone on Zoom would like to
It was already heard.
speak in support of this bill,
Call the roll,
please raise
please.
your hand electronically.
Ayes 9, noes 5.
Thank you.
Thank you, Mr. Chairman. Next one we have is Senate Joint Resolution 235 from Senator Peake. This was a resolution to call for a convention of the states. We took about 10 minutes of testimony from folks who felt very strongly that we ought to reconvene a convention to consider some amendments to the Constitution. We had some debate and dialogue about what that meant. Some of us felt that reopening the Constitution, even for amendments, could result in a much greater revision to our entire form of government, as what happened in, I think it was 1783 or so. And in light of that, the subcommittee recommended PBI in the bill 3-1. I would so move.
Second. The proper motion second that be PBI SJ 235. Open the roll, please.
Ayes 9, noes 5.
Ayes 9, no 5. Thank you. Next, please.
Thank you, Mr. Chairman. Senate Joint Resolution 242 was Senator Evans' resolution. This has to do with repealing the same-sex marriage prohibition from the Constitution, otherwise known as the Marshall-Newman Amendment, colloquially. We saw a version of this last year. This version's a little bit different. Last year's amendment by Senator Evans not only repealed that language, but also included an affirmative right to marry. This one just has a repeal of same-sex marriage. It does not have the affirmative right to marry. And the subcommittee took testimony, recommended reporting that 3-1. I would so move.
Second. Properly motion second SJ 242 be reported. Open the roll, please.
Ayes 9, noes 5.
Ayes 9, no 5, noes 5. Thank you so much. Next, please.
Thank you, Mr. Chairman. Senate Joint Resolution 247 was a resolution by Senator Hashmi, which would basically, she described situations they've had with gentrification within the city of Richmond, and that there are certain people that have been longtime residents of the city whose property taxes have been rising massively because of the rising value of their property. I mean, people have been there 20, 30, 40 years, and the city right now does not have authority under our Constitution to set up any kind of an alternate tax structure for folks whose ability to pay taxes is limited by income unless they're elderly. And this would give them, or give us additional authority to give them additional authority to set up an alternate taxation method or subsidy program for folks who are low income. The subcommittee heard the testimony. We recommend reporting that 3-1, and I would so move.
Can I ask, Mr. Chair, can I ask a question?
Yeah.
Senator Servell.
Senator Hashmi, is she still
Senator
here? There she
Hashmi
is.
here?
Yeah, she is.
So is this an exemption that would go to the property owner but not stay with the property? What I'm thinking about is property that's occupied by low-income people and that at some point becomes gentrified and like some parts of the city of Richmond, for example, and some parts of a lot of older cities. What happens if the property does get redeveloped?
Thank you, Mr. Chair. It does stay with the homeowner, that particular exemption or that reduction of taxes. So it's single-family homes that are continuously owned and occupied as the sole dwelling for a minimum number of years. So it would stay with the homeowner whose property is facing increasing tax burden because of gentrification.
Thank you. There's been a motion and a second. We report SJ 247. Open roll, please.
Mr. Chairman, there's a question.
Yes, sir.
I just, on
sorry.
this one, I think there was some discussion about other language, and I think there were some attempts at it, but I just want to point out, this would not really help those people who live in more rural areas who find themselves in the same situations as they develop, because they could have a farm and it might not work in the same manner. And I think that the impact of communities or areas growing and the land values changing substantially can hurt those individuals just as well. So I do have some concerns. This only impacts one part of the state, and the issue is more statewide.
Thank you so much. Any other question from the members committee? If so, we have a motion and a second on the floor. Please open the roll, please.
Ayes 9, noes 5.
Thank you so much. Next, please.
Thank you, Mr. Chairman. The second to last bill we have was Senator Obenshain's joint SJ 254. This was, again, a resolution that we saw last year relating to charter schools. The Constitution of Virginia requires schools to be run within divisions. Right now, the only divisions we have are local divisions set up, locally by county or city. And this would create a new separate division run by the Board of Education called the Charter School Division. Again, it's a policy that we heard last year. I believe we rejected it last year. Subcommittee recommended PBI in the bill 3-1. I would so move. Sorry.
Proper motion second will be PBI SJ 254. Open the roll, please.
Ayes 9, noes 5.
Ayes 9, noes 5. What else you got there?
Thank you, Mr. Chairman. The last one was Senator McClellan, who's not here. You want to wait for her to get back before I do hers?
Any controversy about it? Let's see.
Yeah. Yeah, why don't we wait for her, and we'll do her two bills and my bill when she's back.
Yeah, how about the one from Monty Mason? That's controversial.
I don't believe that was in subcommittee.
Subcommittee, okay. Okay, you're good to go, all right? All right. Jen has two here, okay. All right, then what we would do then, let's go to the regular calendar until they get back, okay? Senate Bill 884. But back up, am I missing something? Yes, well, we can do the appointments first, yes. Let me hear this one first, then we do the appointments.
All right, that's me. Thank you, Senator. Thank you, Mr. Chairman, members of the committee. Senate Bill 884 is otherwise known as the Voter Confidence Restoration Act. And, Mr. Chairman, this bill, this fine bill, was brought to me as an idea based on constituents coming to me and saying that in 2020, many Virginians either went to the polls to cast a vote, only to find out that for the first time since they registered to be a voter, that their sacred vote had already been cast. We had election officials report nefarious and questionable thumb drives that just happened to have enough votes to change the results of a congressional race, and the list goes on. The bottom line is that beginning in 2020, many Virginians for the first time ever questioned the sanctity, processes, and results of our elections, and we've yet to restore that trust. After listening statewide to many Virginians, I feel this bill is in order. There was actually a poll that was done by CNN in February of 2023, and in that poll, it said that 56% of respondents said they have little or no confidence that American elections reflect the will of the people. It's 56%, up from 52% who felt that way in September and 40% in January 2020, and that means almost 3/4, Mr. Chairman, 74% of Republicans are now skeptical. But it's not just the Republicans, it's the independents too. 59% of independents and only a third of the Democrats. So if you're one of the 32% of Democrats that don't question it, understand that there are people out there that do question these results. This bill understands the importance of restoring that confidence by getting back to the basics of election integrity and ensuring safe, transparent elections that all voters, not just Senator Deeds, trust. Senator Deeds trust these elections. We must put the guardrails back on our Virginia elections to restore confidence of the people in our election process and outcomes. Elections are the foundation of our peaceful transition of power in our constitutional republic. Virginians, all Virginians, must be able to trust and have confidence in the election process, to have confidence in the election results as these elected leaders make decisions that affect every aspect of our lives, especially during COVID. So we're going to talk specifically now about Senate Bill 884 and what it addresses and what it does not. 884 addresses many of the concerns voters experienced during the 2020 presidential election and seeks to ensure these issues never happen again. Number one, it repeals provisions of the law requesting and permitting same-day registration. Number two, it requires a legitimate excuse to vote absentee in limited cases like active duty military serving overseas. Anyone who meets the limited criteria for voting absentee will have to notarize their mail-in ballot. Number four, voters are encouraged to vote in person on Election Day and present a valid government-issued photo identification. Number five, the 45-day election season is completely eliminated. 6, absentee drop boxes are completely eliminated. 7, all ballots must be received by the general registrar by 7 p.m., the close of polls on Election Day, in order to be counted. This act requires presentation of a form of identification containing a photograph in order to vote. 9, it repeals the provisions of law permitting a voter who does not have one of the required forms of identification to vote after signing a statement that he is the named registered voter he claims to be. And 10, the Voter Confidence Restoration Act eliminates the use of electronic poll books and voting machines and requires that ballots be manually tabulated in order to determine the results of an election. And just to remind you all, because I'm not going to repeat it, is in the last time we had this discussion, we were talking about in the last election in 2020 in Prince William County, there was a manual count that was done, and then it was tabulated. Do you remember how much percentage it was off? 7%. The last thing that I'm going to leave you with is this, is that in a November 18th, and this is 2014, Red Team testing report, Dominion Democracy Suite Adjudication, stated that a remote user could leverage most of the vulnerabilities across the network to obtain information about the system, voter ballots, and results, or gain remote access to the system. And if we remove that access is gained, then recovery of user credentials through the system memory, the RAM analysis could be executed and used to modify the back-end database of the EMS server. And one of the contributors of this report was none other than Steve Weingart, who's on CISA. And I know that Senator Boyska knows that agency. It's the Cyber Security and Infrastructure.
About wrapping it up.
Yes, Security Agency, which is an agency of the United States Department of Homeland Security. One of the things that I would like to do with this bill, Mr. Chairman, if I could, is I would like to add an amendment, and I have not submitted this yet, to also include, to eliminate the use of Soros-sponsored ERIC, which is the Electronic Registration Information Center. And I apologize, I should have done that at the beginning of the bill, but I would like to.
Do we have a concept, Mr. Chair?
Brooks, can we put in the concept what she was talking about? Amendment. Wait a minute, you know.
Mr. Chair, if what Senator Chase wants is a prohibition on joining ERIC, we could probably do that. That's fine. That should be easy enough.
Okay. Could I have a second? A proper move a second. That amendment, all in favor, use sign saying aye. Okay, the amendment's done. Thank you so much. Yeah. Go ahead, please. I've already ruled, just the amendments. Can we wrap this up?
My last 2 points are this, and we started to touch on this last week, and this is new information. There are some experts here today that I hope will have the opportunity to testify about something called Albert sensors. Albert sensors are installed into every voting computers in Virginia to allow the federal government to monitor and intervene in our state elections, threatening our state sovereignty. We've already talked about Prince William County and what happened. Mr. Chairman, we want to restore the confidence of the people in their election process. This is so important. It's important to both sides of the aisle. What this bill does, in essence, is to put the guardrails back on our Virginia elections with additional assurances, including eliminating voting tabulators, voting computers, and getting back to hand counts until we can restore the trust of the people. You saw the numbers, Mr. Chairman. Then that's CNN. That's not exactly the most conservative.
You'll guess who wants to speak. You can take up their time.
Yes, okay. Well, then I will. I thank you for allowing me to present this, and I've got a number of people who want to speak in favor of the bill.
Yes, ma'am.
Thank you.
What we can do, because of time, we have 5 minutes for the pros and 5 minutes for the cons, and then we have those on virtual. Those in support, please come forward. Anyone in support, please come forward.
I already see one speaker on Zoom. If anyone else would like to speak in favor of this bill, please raise your hand electronically. You'll be called on after in-person testimony. Thank you.
You have no one, so no one in support? You got to come up, Doc. Come on up. We got 2 speakers on the support of 3.
Hey, thank you for your time.
I spoke. Please,
sir.
1 minute. I was trying to see how many speakers do we have. We have 3. We have 3 speakers, so a minute and a half apiece, please. A minute and a half apiece. Thank you so much, sir.
Thank you. Last year I spoke on this bill, and I was here earlier, or last week, when Senator Deeds asked, is this the same bill that you presented last year, Senator Chase? Nothing could be further from the truth. There's so much more evidence that's come out since that time. There's lawsuits all over the country. Loudoun County is being sued. The state of Virginia is being sued. These machines, as I said then, are computers. And I presented, we owned and bought numerous machines. And those machines have, the simplest thing is there's 255 pages of instructions in the ones we use principally in 50 counties in the state of Virginia. And there's no one that understands and goes into those machines without the codes. So, and their codes are not allowed to be given to the precincts. That's terribly egregious. And the other thing is this new early warning system. There's a picture of it called the Albert sensors. Albert sensors are now used. The state of Washington prohibits them because they had some egregious happenings in counties that they knew the vote should have been accurate. And the Albert systems are taking away the state of Virginia's right to control their elections. That's a federal mandate.
Thank you so much, sir. Thanks for coming. Next, please.
So I never thought I would stand in front of this organization here. I want to say that 3 years ago, I would have thought that our election systems were fair, with some exceptions and maybe some big cities. The paradigm has entirely shifted. I'm a CPA. I have a fellowship in the Society of Actuaries. I have an MBA in finance, and I could go on. I've spent several thousand hours now looking at our election systems, and I think that we have serious problems. The computers are the vectors for major election fraud, and please take it seriously. Here's a window sticker, and it says now, demand election reform, ban the machines, hand count ballots, no mail-in voting. We are serious about that. It represents to us a fundamental problem in this country that's going to take us down if we're not careful.
Thank you so much, sir. Next, please.
Donna Machin, Foster, Virginia. This is a comprehensive bill that I love, and I know my husband and I would both like to see this pass. Election day has always meant a great deal to my family, so this is a personal note. We love it so much that my husband and I consider date night to be going out to vote, and we do it on a regular basis as a rule. However, now we are both racing to vote to make sure that our vote counts. So we have to do it early. I would love to see this change so that I can have confidence in this system that has always worked under the Constitution. Thank you.
Thank you so much, ma'am. Anyone in Zoom to speak in support of the bill?
Yes, we have 4 speakers to speak in support of this bill. Tyee Mallory, please unmute and provide your testimony now.
30 seconds apiece, please. Thank you so much.
Hello, I'm Tyee Mallory, speaking on behalf of the Virginia NAACP, and we wholeheartedly and strongly oppose this bill. Thank you, Mr. Chairman.
Oppose the bill. Thank you so much, ma'am. Next, please.
Stephen and Rose Quinnen, please unmute and provide your testimony now.
We're from Anita, Virginia. I want to say Virginia's on. We're on.
Okay.
Virginia's electoral system has been proven to be corrupt, giving access to foreign powers and many others to modify voting outcomes and to count many illegal ballots. This Senate bill is designed to cure this horror. Any senator who does not vote for this bill is participating in massive election interference and is guilty of treason. The punishment for this act includes removal from office and prohibition from ever holding any elected office again, and further, more serious punishments as well. You must vote to approve and move this bill forward to the full Senate.
Thank you so much, sir. Thank you for your time. Next, please.
Vic Nichols.
No.
Vic Nichols, please unmute and provide your testimony now.
Thank you. The NCOA check with the registered voter list and the daily absentee list, we already know give thousands of discrepancies.
Thank you, Mr. Nichols. How you doing? Next, please.
John Mills, please unmute and provide your testimony now.
Okay, thank you. John Mills. I support this strongly. We need to do several things with our registrars and election boards. We need to establish a clean voting roll. We need to demonstrate a trusted process for taking voters from the DMV rolls. We need the election board to provide proper guidance. We need to ensure the security and integrity of the critical infrastructure, all aspects, and the registrars need to understand this. We need to validate the security of where our data is being stored. We cannot accept outside funds. We need to leave ERIC. We need to use a trusted ballot, and we need to move paper only, and we need to have a better audit process.
Thank you so much for your time, sir. Thank you so much. Time is up. Next, please.
Lastly, Daryl Bowe, please unmute and provide your testimony now. Daryl Bowe, please unmute and provide your testimony now. If you cannot do so, we will move on.
Thank you so much for it.
That completes the speakers.
Thank you so much. Those who are in opposition, please come. The opposition side, total of 5 minutes together.
Deb Wake, League of Women Voters of Virginia. We
Yes, ma'am.
strenuously oppose this bill. It would reverse most election law improvements that Virginia voters also support, including 45 days of early voting, more flexible voter identification, and vote by mail options. This bill would add new restrictions and discourage many voters from exercising their right to vote. Additionally, we describe more fully in our written statement that the bill for no valid reason would eliminate the use of electronic poll books altogether and would dictate manual tabulation of all ballots. At present, all machines used in elections must be from a list of Department of Elections approved vendors and must meet federal and state security standards. Please vote no.
Thank you so much, ma'am. Anyone else present in opposition? Anyone in Zoom in opposition? Thank you.
Mr. Chairman, there's a Daniel Bowe that's one of our experts. I don't know if he's trying to get in or not, but.
No, I'm going to let him speak, but he's not there.
Okay.
So if he's there, I'm more than glad to, but he's not there. So members of the committee, any comments?
Mr. Chairman,
Yes, sir.
although I've been threatened to commit treason by doing so, I'd move to PBI the bill.
Second. Third.
Hold on a minute, wait a minute now. Still, I want to make sure that members, do have a motion, but still there has been properly moved and seconded to be PBI the bill. Any such comments from the members committee? And your person not there yet.
Apparently not. I
So
apologize.
I want to make sure that you.
I appreciate that.
You satisfy
Thank you.
that, right? Open the roll up, please.
Ayes 9, noes 5.
Thank you, Mr.
Here's
Chairman.
the report. Thank you so much, Ms. Peabody. Now we're going to go to governor's appointments. Is Mona Mason back yet? Well, we can think we'll be fine. You got the proxy, thank you. Governor appointments, I think we're seeing that we can look at confirm the governor appointment 270.
Mr. Chairman.
Yes, sir.
Thank you, Mr. Chairman. So it's my impression, having talked with a few others about this, that I don't believe there's a whole lot of, unless the folks on the other side have any amendments they'd like to make, but I don't believe there's a lot of controversy about Senate Joint Resolutions 270, 71, or 72. In light of that, I would move that we take up 270, 71, and 72 in a block, and I'd move to report those in a block.
It's been properly, Brooks, we can do that, right? Thank you. It's properly moved that SJ 270, 271, and 272 be approved in a block. Open the roll, please.
Ayes 14, no 0.
Ayes 14, no 0. Thank you so much. Now we have, let's look at 273. I believe there were some amendments.
Mr. Chair.
Yes, sir.
I would move that we remove lines 20 and 21 from Senate Joint Resolution 273.
Second.
Members are seeing that on 273. What lines are there again?
20 and 21.
20 and 21. The proper motion second that remove lines 20 and 21 from.
Mr. Chairman?
Yes, sir.
I don't know that everybody that's paying attention to this can see what the names that's on.
Okay.
Yeah, that's the State Health Commissioner, Mr. Chair.
What is his name, please?
His name is Colin Green.
Colin Green?
Colin Green.
You got that? You got it? Okay, with that, open roll, please. Do we have to, that's a voice vote. All in favor, you sign them saying aye?
Aye.
All opposed?
No.
Okay, ayes have it.
With that amendment, I'd move, Mr. Chair, that we report the bill.
Properly moving, second, we report SJ 273. Open the roll, please.
Ayes 14, no 0.
Ayes 14, no 0. Thank you so much. SJ 276.
Mr. Chair. I've got a motion on that one, too. I'd move that on SJ 276, that we remove lines 468 and 469. That's Mr. Ellis from the UVA Board.
Do we all see that?
And there are technical amendments, but that won't be a block. If we want to do this.
What we do, let's do the technical amendments first in 276. Let's do those first.
Okay.
Mr. Chair, The technical amendments on line 28 of the introduced bill after 2022, strike the remainder of line 28 and insert to serve an unexpired term. On line 29 of the introduced bill after succeed, strike information missing and insert Joanna Young. On line 30 of the introduced bill, after 2022, strike the remainder of line 30 through years on line 31 and insert to serve an unexpired term. On line 31 of the introduced bill, after succeed, strike information missing and insert Eddie Reyes. On line 599 of the introduced bill, after Virginia, strike chairman and insert member. And on line 882 of the introduced bill, after succeed, strike information missing and insert Carol C. Ballard.
Amendments, do we have a second?
Mr. Chair,
Do we have a second?
I'll second.
Go ahead.
I'll second, Mr. Chair. I just want that last technical amendment. If you could repeat that, I'd appreciate it.
Last, yes.
Mr. Chair, it's on line 882 of the introduced bill. After succeed, strike information missing and insert Carol C. Ballard.
Okay, I'll move the technical amendments.
Do we have a second? Do we have a second? It's been properly moved and second. The technical amendments are given, the six of them. We approve. All in favor, the sign and saying aye.
Aye.
All opposed? That has been done. Now we're back to the
Mr.
original
Chair,
motion.
yes.
Yes, sir.
I would now move that we remove lines 468 and 469, that's Bert Ellis, from the UVA Board of Visitors.
Okay. The proper move and second that remove those lines, Mr. Ellis from the board. Please open the roll, please.
Voice vote.
Voice vote on that one? All in favor, on the amendment, I'm sorry. All in favor, use the sign saying aye.
Aye.
All opposed? Ayes have it.
Mr. Chairman, before we take up the full bill, I have another amendment.
Say that one more time, please.
On line 13 of number 276, it says Virginia Chief Diversity Opportunity Inclusion Officer, which is not the the title from the code. It should be Chief Diversity Equity and Inclusion Officer. And I would move that we replace the word opportunity with equity on line 13.
Second.
Brooks, anything wrong with that? That's good to go? The proper move and second, the amendments. All in favor, use the sign saying aye.
Aye.
All opposed? Ayes have it. Thank you so much.
The resolution as amended be reported.
It's been properly moved and second to SJ 276. Resolution be reported. Open the roll, please.
Ayes 14, no zero.
Ayes 14, no zero. Thank you so much.
Mr. Chairman,
Yes, sir.
Senator Evan, in pointing out that last technical amendment that he just made, also made us realize that that same amendment needed to be made in Senate Joint Resolution 271. And so in light of that, we need to rewind the first vote, the first block vote, and then do that over again. So having voted on the prevailing side by which we reported Senate Joint Resolutions 270, 71, and 72 on a block, I'd move that we reconsider that vote.
Do I have a second?
Second.
A proper motion second, we reconsider that vote under the SJ 271?
72, 70, 71, and 72.
Okay. Is that a voice vote?
No, it's recorded.
Please open the roll on those two.
Ayes 14, no zero.
Mr. Chairman.
14, no zero. Yes, sir.
And in light of that, I would move that we report Senate Joint Resolution 270 and 272 in a block.
Second.
Wait a minute.
We'll leave 71 out.
Wait a minute. I thought the change was made on 71 and 72.
We haven't done anything to 70, 71, or 72 yet. They're before us unamended.
Okay.
I need to make an amendment to 71, so I'm moving to report 70 and 72 in a block.
Okay. The proper move, 70 and 72 in a block. Open roll, please.
Ayes 14, no zero.
Ayes 14, no zero. Thank you. Next.
Mr. Chairman, I assume we're now back to Senate Joint Resolution 271. And if that's where we are, I would say on line 271, I'm sorry, in Senate Joint Resolution 271, on line 13, I would move that we strike the word opportunity and replace it with the word equity.
Do we have a second? Second. Proper move on 271. This voice vote. All in favor, use the sign saying aye. Aye. All opposed? One no. Thank you so much.
As amended, I move we.
Properly move and second, we agree to the resolution. All in favor, use the sign, vote on the machine, please.
Ayes 14, no zero.
Thank you so much. Ayes 14, no zero. And we can get back to the regular calendar, I believe.
Yeah, Mr. Chairman, Senator McClellan's back. We can finish the subcommittee report now that she's back, I think.
Which one is that?
Why don't we start with the bill, the last bill on the docket, which is
Mr.
for
Chairman,
constitutional amendment.
Can I ask a question before we get to that?
Yes, sir.
SJ 224, is that was
224?
Was that in the subcommittee report? Did we?
No, it was not.
No.
Okay, so.
Well, I'm sorry, sir. I thought that wasn't in that case. Then no, that's not in the
So
subcommittee.
I didn't see Senator Chase here, and I didn't know.
No, that's not in the
Okay.
subcommittee. Okay. All right.
So we jumped to SJ 255?
Yes.
All right.
Senator McClellan, I think would probably be better for her to explain her resolution than me, so she could take a shot at it.
Oh, wait, which one did you say?
255.
Okay. This is the first reading of a constitutional amendment for reproductive freedom that in substance takes the precedent of Roe versus Wade and its legal progeny and puts it in the Virginia Constitution.
Mr. Chairman, the committee took substantial testimony on this, and the subcommittee recommended reporting the bill 3-1. I would so move.
Second.
It's been properly moved and second. The bill, open roll, please.
Ayes 9, noes 5.
Ayes 9, noes 5. Thank you.
Mr. Chairman.
Yes, sir.
Okay, now we have what remains of the subcommittee report, or the two bills that related to recall of elected officials. Or, I'm sorry, one is removal and the other one is recall. And the subcommittee heard testimony on those bills and
What number is that, please, sir?
Senate Bill 1431, which is my bill, and then Senate Bill 1328, which is Senator McClellan's bill.
Okay, let's do 1431 first,
Well,
please.
let me lay the groundwork here. So,
Okay.
yeah, I think probably makes sense. So, as the members know, we currently, the only way a member of a statewide official or a member of this body or the body across the hall, the only way they can be removed is by either impeachment or removal within our own internal processes. The current statutory removal process only applies to local elected officials and constitutional officers. And so that's what both my bill and Senator McClellan's bill have to do with is local elected officials. My bill is a Boyd Graves recommendation where the Boyd Graves Commission basically went through Supreme Court cases for the last 100 years and then attempted to amend the existing statute to conform it to constitutional law so the public was better on notice as to what current law was. Senator McClellan's bill instead chose to sort of junk that current process we have today where there's a petition process and the Commonwealth Attorney looks at it and then the Commonwealth Attorney files something with the court and then the court decides hers, basically takes pieces of that, but it ultimately results in a recall election instead of a statutory, instead of a judge removal trial, I guess you could call it.
Okay, question for you. Now that you keep going from your bill to her bill, is it necessary to put those two into one bill?
No, I'm going to explain what basically the subcommittee decided that Senator Bell, I think it was, suggested that we take good pieces in both and make one. Senator McClellan and I went back and forth and debated that, and we thought the safer course of action would be to leave my bill alone to travel on its own way and then to make some amendments to hers that leaves it as a judicial process, but makes some other changes. We thought that would be the safer course of action, that where both bills and the policy in both of our bills might in some ways survive and make some useful modifications. So that was what we decided to do, but the subcommittee did not get to consider that or specifically hear that proposal. So,
Mr. Chairman.
Yes, sir.
I think that we need to pick one way or the other. We either need to, I think the issue that's trying to be addressed is important, and both Senator McClellan and Senator Servell identified that. The question at the end of the day, I think, is pretty simple. Once you go through the process, are you then going to have a new election 45 days, or to make the determination? The election won't just make the determination about whether the violation occurred, or you're going to let a court make that decision.
Yeah.
So,
Mr. Chair.
Wait a minute.
So for me, it's a
time out. Please go to the chair, please. I'm trying to talk without my bees. I don't want to use my bees today, so go to the chair.
Mr. Chair.
Yes, ma'am.
It might be helpful to answer Senator McDougal's question. There is going to be a substitute to my bill. I am a pragmatist, and recognizing that the makeup of the House of Delegates has not changed since last year, they may not be ready for the policy change to go to an election. However, there are some policy changes in my bill that may be likely to pass. Senator Servell's bill does not include policy changes so much as codifying Supreme Court precedent around the current recall process. So the reason we decided to keep them two separate bills is, his is more codifying existing court law, whereas mine will make a handful of policy changes related to the threshold for petition signatures required to initiate a recall proceeding, and the time frame around when that could occur. That's a policy change, whereas Servell's are more codifying legal precedent.
Mr. Chairman.
A question before you do that, I'm going to call you next. Now, look what we got here now. We got three lawyers here talking, and some of us not lawyers. To me, I think one bill should do it, and I understand you want to separate it. So we're sitting and listening. I'm listening very carefully. We got three lawyers trying to work out something and say, if we get something out of here. And I want to make sure someone in the audience ask me, say, Spruill, what did y'all pass? I want to be able to say this. So we got three lawyers trying to interpret what they want so they can prove it in court. I'm not a lawyer. I'm not going to court. Now, to me, if we do not make it understandable the two bills, then we're not going to get nothing out of here. Because I want to make sure that what y'all are trying to do is that the rest of us who are not lawyers, they won't say it, but I'm going to say it, who are not lawyers, I want to get out here and say, hey, this is what we did on this particular course. If not, I will call my lawyer, Senator Stanley, will help me out. Isn't that right? I'm here. Thank you, sir. Now, sir.
Thank you, Mr. Chairman. I just talked with Senator McDougal about it, and he thinks it would be clarifying to everybody if we did Senator McClellan's bill first, because it has the policy changes, and then after we take action on hers, then we do my bill, which just confirms the existing reality. And given my conversation with her, they are not in conflict.
Jen, if you don't mind, Senator, you might go down front. I'm going to look at you face to face.
Okay, Mr. Chair.
What bill?
I have a substitute for 1328.
I move
1328.
And I don't know if you all have.
We'll have a second to remove the substitute. Second. The properly move the substitute. All in favor, you say I'm saying aye.
Aye.
Now you're going to explain the substitute.
I am.
Yes, ma'am.
Is it online?
The substitute does three things
Yeah, it's online.
to change the current recall process. It all deals with the petition signatures that someone needs to get to initiate that process. First, on lines 36, it increases the threshold for the number of petition signatures you have to get to initiate the process. Currently, you get 10% of the total number cast of votes in the last election. This increases it to 30% because it is closer aligned to the number of petition signatures you would need to get on the ballot to begin with. It shouldn't be easier to take somebody out of office than putting them in. Second, it limits the time period for collection of signatures to 90 days so that you don't have someone who is trying to do a recall, perpetually as harassment. And third, it prohibits initiation of a recall within 75 days of a primary election or within 30 days of a general election, so that you're not initiating a recall as soon as somebody's been elected or right before you're going to have an election to vote them out or reelect them at all. That is all the substitute does to the recall provision now.
Senator Maduga, I'm calling you first.
Mr. Chairman, I like the 30%. I think that makes some logical sense. And I like the 90 days so you don't leave it open-ended. My questions are around the time frames. Early voting starts 45 days before election, so you could still be collecting these signatures during the early voting time. Why wouldn't you can collect them 90 days, 75 days of primary election, and through the date of the next general election? What, there's no primary?
So you would want to increase. The point here is that you're not going to be initiating this so close to an election that you can use it harassment. If you want to use a different number, I'm open to that.
Mr. Chairman, I think maybe mine is how it's written and not the numbers. If in little I, Mr. Chairman, is 75 days of the primary date through the general election, I think that probably fixes my problem. But as Mr. Chairman, as you know, vast majority of nomination processes are not by primaries. And so if you had a convention, then this would still allow you to pull signatures up to 30 days of the election because there'd be no prohibition. So I think maybe it's wording, not policy.
Start with them a minute. So,
does that make sense, Brooks?
Brooks, can we do that?
Mr. Chairman, so the limits right now in the draft are within 30 days after any general or special in which the officer, the one on the petition, is a candidate.
Was a candidate.
Or 75 days of a primary election in which the officer is a candidate, and through the date of the next general election if the officer is the winner of the primary. So if there was no primary, no petition written.
Right. So, Mr. Chair, if I can repeat that in plain English, is that okay?
I'm a lawyer. I understood that.
Okay.
Go ahead, please.
For the non-lawyers, so, and just so that I can make sure I understand this correctly. So 75 days before the primary, through the general election, when someone is an active candidate, you would not initiate a recall because the election is going to be the recall. And then once you have the election, there is a 30-day window before, if anybody wanted to initiate a recall, they could start it.
Mr. Chairman.
Yes, sir.
This is what if I'm reading this, and you can tell me that I'm reading it wrong because we just saw it. But let's say that the candidate, a sheriff candidate, is standing for election this year. The locality chooses to have a convention. That convention is in May, and there is no prohibition until 30 days before the election if they have a convention, because that's where little I gets into.
Mr. Chairman.
Yes, sir.
I think the senator's on the right track, but not reading it quite correctly. So my reading is under little I, the 30-day prohibition has to do with after the election. So it's 30 days after the general or special. So in other words, George Santos.
Colin, please.
And then, wait a minute, Mr. Chairman.
All right.
And II has to do with the window before the election. So it's 70-day, 5 days before the primary or the general, or there's a blackout 30 days after the election has occurred.
He's making it, Mr. Chair, I think he's
Yes,
making
yes,
a
ma'am.
different point.
All right, talk to me.
And I think the way to fix his concern is, rather than saying 75 days of a primary election, it should be, and help me get the correct term of art, but it's 75 days from the nomination event, whatever we call that. So if it's a convention, it's 75 days of that. Could be the deadline when candidate nominations have to, what's the right word there?
Mr. Chairman, Senator, so I think on line 40, after a primary election, we would put or party nomination procedure in which the officer is a candidate.
What about
and
the
then
caucus?
through, that would be included in a party nomination procedure, right? Under 24.2, that's how we use that term. So party nomination procedure would include a firehouse, a caucus, anything that's in the party rules. And then again, on line 41, if the officer is the winner of the primary election or party nomination procedure.
You'd need that on line 72 as well.
Right, and then repeated, yeah.
So I so move.
All right,
the
now,
amendment.
the proper move and second. Now, read again what I'm voting on, please.
Okay.
So we all agree. I want to make sure my two lawyers up here won't say a word.
Yes.
Please.
So, Mr. Chair, if this bill passes, if someone wanted to initiate a recall procedure, they would have to get petition signatures equaling 30% of the votes cast in the last election for that office to be able to initiate it. They would have only 90 days from start to finish to collect those petitions. Very similar, there's a window where you have to collect to get on the ballot. And there would be a blackout period from 75 days before a nominating process through the general election, or 30 days after a general election where a recall could not be initiated.
Thank you.
Thank you.
Mr. Chairman.
Wait a minute.
Mr. Chairman,
Councilman Dugan.
I think that fixes my concerns about little I. The question I have about double I, question I have about little I is, so you have an individual, let's say, that goes through the primary process. They're nominated by process in June. They run for election. So once they start that 75 days before the primary, there can't be, they get elected on, let's say it's early November, November 2nd. They're still in office for the first term, and they haven't even started office for the second term, and now 30 days you can file one of these. Wouldn't it be 30 days
Swearing
after
in.
their new term of office begins?
Yes, I so move that amendment on lines 39 and 71.
All right, the proper move and second, line 31. All in favor, use Sam saying aye. Now, I want to hear them from the lawyers no more right now. Senator Bell, Bosco, and Evans, any questions that you have?
Mr. Chairman.
Yes, sir.
I'll just make a comment. I know that the discussion started about what we were doing at the subcommittee, and we talked about concepts there, and it was hard to make any final decisions, so we didn't make a recommendation because we didn't have the actual changes in a draft form so we could see them. But I will say I believe that Senator McClellan has done a great job of focusing this legislation and going in a different direction, and it is not duplicative of what Senator Saravel is doing. So I do think they're two distinctly separate pieces of legislation now.
Okay. Now, another question
Chair.
from, wait a minute.
Okay, yeah.
I don't talk, I don't hear nothing from no lawyers right now. Anybody here who is not a lawyer, got any comments or any questions? And now, so to keep this, I thought you were a lawyer. Aren't you a lawyer?
I am. I thought I was your favorite lawyer.
You are.
I guess
I
I'm not.
apologize.
I thought
I
I
apologize.
was, but I guess I'm not. That's
Yes,
okay.
sir, I apologize. Go ahead.
Mr. Chairman, I had a question for council or the patron. Who does this apply to? City council, board of supervisors, and school boards? It does apply to constitutional. I thought they were excluded, and constitutional. Is that, am I correct? That's it? All right, thank you.
All right, now, as far as we're concerned, are all minds clear up here before I call anybody in the audience to speak in favor? Up here, are all minds clear? Scott, you are happy, right?
Yeah, I'm happy.
Maduga, you are happy. Maduga, say yes. Just say yes.
Ecstatic.
Thank you. Here's yes. Jen, you are happy, right? My Lord, you are happy, right? Now, so all minds clear. I want to make sure that when we call up the general public to support a bill, I want to make sure at least they know what we're talking about. Now, so before a motion is made, anyone in the audience are in support of this bill? Anyone in support of this bill? Twice.
We have speakers on Zoom, Mr. Chairman.
Anyone in the audience support this bill? 3 times. Now, how many speakers do we have in the Zoom in support? 2. 30 seconds apiece.
Amy Bergner, please unmute and provide your testimony now.
Thank you, Mr. Chairman and members of the committee and Senator McClellan. I'm Amy Bergner with Virginia Democracy Forward. It's a grassroots Democratic group promoting good governance in the Commonwealth, and we strongly support SB 1328 as amended by Senator McClellan. We think that bringing consistency and transparency to the process for recalling elected officials is a great thing for the Commonwealth. Thank you.
Thank you so much, ma'am. Next, please.
Louisa Boyarsky, please unmute and provide your testimony now.
Thank you. I am representing the Virginia Grassroots Coalition, which is a statewide coalition of over 50 grassroots groups that represents about 15,000 Virginia voters. We have been working with Senator McClellan on this legislation, and we want to note that the changes recommended are in line with the recall processes in virtually all other states, and we're very pleased with the amendments that have been made, and we urge you to vote for SB 1328.
Thank you so much, ma'am. Now, is anyone in the audience in opposition of the bill? One time. Anyone? Yes, ma'am. Come on up, please. Anyone in opposition of the bill? Yes, ma'am. Yes, ma'am.
I'm not a lawyer. Don't play one. But I'm confused. If you have an election for a candidate and the people vote to re-elect or elect that candidate, isn't that a statement of we don't want to recall that person because we just re-elected that person? Why would you have a recall 30 days after an election unless you were questioning the validity of the election?
Mr. Chair, under current law, you could initiate a recall anytime you wanted. What this bill does is put a blackout window so that you cannot initiate a recall within 30 days after an election or 75 days before a nominating process for a new election. So this is, your problem is with current law.
Correct.
Yeah.
Okay, thank you. Thank you so much.
Mr. Chairman?
Wait a minute. Yes, sir.
Mr. Chairman, maybe if, I think Clarabelle made a point, if we could just, Brooks, walk us through what that statute is today so that we all understand how this changes what it is. Because today, if Brooks tell us if we're wrong, 10% of the number in the prior election can recall at any point, even the day after the election.
Oh, okay.
Is that accurate?
Mr. Chair, Senator McDougall, yes, that's correct.
Okay. So, Mr. Chairman, just this puts in some guardrails so that it can't just be at any point in time. You have to have a higher percentage, and you at least have to wait till the person is serving in office before you move to recall them, which you don't have to do now.
Correct.
Thank you so much. Anyone else?
Mr. Chair, one other
Yes, sir.
question. So council or patrons, what recall process, has anybody been recalled in the last 2, 3, 5 years?
Mr. Chair.
Yes.
There have been many recalls initiated.
Has anybody been put out of office?
There have been few that have actually succeeded, but we have seen an increase in the number initiated.
But none of
The grounds are very limited.
Please go to the chair.
I'm
Mr.
sorry.
Chair, yeah.
Yes, sir.
Have any succeeded?
Mr. Chairman.
Yes, wait a minute. Let's answer this question first.
He can answer it, yeah.
You have this question, answer this question?
I think so.
All right.
Several were dismissed on demur at the petition phase. I think one might have actually gone to a hearing, maybe two, but I think both of them the judge denied, I believe. And there was, I think, one other one where somebody just withdrew as a candidate or resigned, I think, before it ever fully played out. But my bill deals with some of the issues that Senator McClellan just mentioned. People found them for the wrong reasons.
Mr. Chairman?
Yes, sir.
I just want to make sure that I'm understanding from Senator McClellan and Brooks. This only changes that door opening filing of the petition. This does not change in this bill the process. So the process, if we pass this bill, would still be that you have to go to court. The court, judge or jury, whichever is selected, would still have to make the determination. This only deals with how you get there.
That is correct, Mr. Chairman.
Thank you so much. Again, any other person in the audience in opposition to this bill?
We have two speakers on Zoom, Mr. Chairman.
Any other person in the audience against this bill 3 times? Those in Zoom, are they against this bill?
Yes, Vic Nichols, please unmute and provide
Yes,
your
ma'am.
testimony now.
A similar Senate charter bill changed for 30% was PBI last year in the House because no area had that level, even at 30%. You're just making the bar so high you can't reach it. You got a crappy legislator. It's hard enough, obviously, to remove them. Why are we making it that much harder? Thank you.
Thank you so much, ma'am.
That completes the speakers, Mr. Chairman.
Thank you so much. Now, it has been properly moved to report. Do I have a second? As amended. Am I right? Please open the roll.
Ayes 13, no 0, 1 abstention.
Thank you. Senator McCollum, you cannot leave. You got to stay here to protect me.
Mr. Chair.
Senator Sproul, I thought I was doing a good job of protecting you.
One that I can take care of real quickly. I've got to run to a committee.
Yes, sir. Yes, sir.
I can do
Please.
that. Senate Bill 1380, I introduced to allow, the Republicans did a ranked choice vote when they ran their gubernatorial race in 2021, and I thought it worked so well that the Democrats we nominate by primary. The primaries run by the state. There were on my count, about 40,000 voters that voted for candidates before. Voted for candidates in the presidential primary the last 2 times around, whose candidates were out of the race by the time the election came around. Ranked choice voting would give those voters a chance to be heard. Alas, I met last week with the director of the Department of Elections, and ranked choice voting is allowed in primaries in 2 states where they have one voting machine statewide. Here in Virginia, we have 4 options of voting machines. It's just not technically possible right now for this bill to become effective as law. So I would ask that the bill be PBI'd and that the clerk send a letter to the director of the Department of Elections and ask her to figure it out.
It's been properly moved.
Figure out how to do this.
Properly moved. Do I have a second? A second to PBI the bill. Please open the roll. What's that number? 1380.
1380.
Thank you so much. Stanley.
Ayes 14, no 0.
No, sir. It takes you too long. Stanley. I'm the chairman. I'm the chairman. I'm the chairman.
I got to leave at 4:30.
Okay. Yes, sir. Take care.
Mr. Chairman, it's great to see you, sir. And members of the committee, I have Senate Bill 1516, sir.
Okay.
It's a simple bill. Basically, and as it reads, is as it has its effect. Any election official who receives guidance pertaining to voter registration or the administration of elections from any instrument of the federal government, any civil society group, or any other third party that is not an agent of the Commonwealth of Virginia has to immediately report such receipt of that information or guidance, and it cannot enact. Let's say someone is offering advice on how to conduct an election, but no election official shall implement any such guidance without the written authorization by the department. So, in a nutshell, it limits the ability of the federal executive branch or any third party or any election group that might have a conservative bias or even a liberal bias, anybody else other than the agent of the Commonwealth, to basically give false information, mislead, try to intimidate, coerce election officials, to administer our election laws in a manner that is inconsistent with federal or state law. What we're trying to do is make sure that we are protecting the primacy, that Virginia runs its own elections, doesn't run it with corporate influence or other governmental influence, and that primacy rests right here in this legislature. And that's the bill, Mr. Chairman.
Thank you. Comments from the members of the committee?
Yeah, Mr. Chairman?
Yes, sir.
I wanted to ask Senator Stanley, when it talks with the federal government, does that mean if there's a citizenship ceremony and they have some kind of tips on getting new citizens able to register to vote, that we would not be able to accept that without immediately reporting it as some kind of suspect communication?
Mr. Chairman, I would answer the gentleman by saying no, it does not. But it does not prohibit that.
To follow up, the words in the bill say shall immediately report such receipt to the department.
Okay. Mr. Chairman, I'd answer the gentleman by saying yes, it does.
Mr. Chair.
Mr. Chair.
Senator Bosco?
Thank you. Mr. Chair, question for the patron. Is that okay?
Yes, ma'am. I apologize.
Yes, sir. So let's just imagine that I am a young 20-something who is excited about an election, and my friends and I are just trying to energize folks. Maybe it's a school project. Maybe we're just activists. Are you saying that we can't share any information? Would this prohibit that group of people from being able to share information about the election in good faith?
Mr. Chairman, I answer the gentlelady by saying no, that wouldn't prevent anything like that. It is limiting an election official who works for the Commonwealth of Virginia from receiving guidance pertaining to voter registration and the administration of elections from any third party. If they receive it, they tell the State Board of Elections what information they received, because they may have received information that might be good information, but then they can only act on that kind of guidance. Remember, it's guidance. In the administration of elections, it must immediately go through the department, and the department says, okay, you can't implement any of that guidance unless we approve it and review it. That's all. It keeps the layer of, Mr. Chairman, it keeps the layer of our voting system within our voting system. And that is to say that all decisions, and if you look at it in this way, all decisions that should be made on the conducting of elections in the Commonwealth of Virginia should be made by the commission itself, by the department itself, and in consultation with someone who may receive guidance. So if someone receives guidance from a third party, hey, you should do your election, conduct your election this way. Well, then maybe they're considering it. They go to the department and say, hey, we've gotten some guidance that maybe we should conduct this election in this manner. The department considers it. The department accepts or rejects it. But the election official cannot act upon it until it's told to the department, and the department takes action of either yes or no.
Mr. Chairman?
Yes, ma'am.
Just follow-up question.
I've never been this popular in Peony before in my life.
Could you give me any examples of real-life experience that this has inspired you to bring this bill? Is there something that's happened that we need to understand? Because I'm just not aware. I worked in the polls for years, and clearly the election officials are in charge. I'm just not understanding the purpose of this bill. I just want to understand it.
Sure. Mr. Chairman, I'd answer the gentlelady, my friend, by saying what we've been having is, and if you think about some of the influences in the last elections on both sides, and certainly election officials can come, we don't ask them to come and not be, they check their party at the door, but we don't ask them to have no political viewpoints. But what we're trying to do is when we have election officials that are unclear on how to carry out Virginia's election laws, then they must rely on the guidance from our election department and our state officials, not any third party. Because we run the elections, it's our laws, and we expect the department to know them better than, say, some third party from, let's say, from Louisiana.
Mr. Chair, just follow-up question. So are you really getting at the attorneys who are watching the elections, who are like they call themselves election protection officers, who volunteer their time to come and supervise, and then if there's a problem with a voting situation, maybe a machine goes out or something, a person would call them and then they would come in and try to assist? Is that what you're getting at?
Mr. Chairman, I would answer the gentlelady by saying I'm not.
Okay.
I'm not trying to get at that. What we're trying to get is to make sure that when we have election officials in Virginia, and you know, and I think everybody on this panel knows that everybody's got some advice, everybody's got some guidance, everybody has a suggestion on how to run things. But if those suggestions are given by third parties, then the election official goes to the apparatus of this body, determines, tells them what the guidance is, and determines whether it should be guidance that would be followed. That way, too, also, it's also protection of the election official. If the election official receives guidance, does not contact the State Board of Elections, does not receive whether we should do it or not, and does it on their own, and in fact it affects an election negatively, well then what we're doing is we're going outside of the laws, the rules and regulations of our own election system. What we need to do is have a linear fashion from a top down, from the State Department of Elections all the way to the election official. That our rules are our rules. We're going to run them this way. We're not going to take outside guidance or suggestions. If we do or you receive something, let's talk about it. If it's good, we'll approve it. If not, you stick with what is our already set policies.
Mr. Chair.
Yes, ma'am.
I have a series of questions. Senator Stanley, you would agree that our elections are also run consistent with the 14th, 15th Amendments and the Voting Rights Act of 1965 and its various reauthorizations?
Mr. Chairman, I'd answer the gentlelady by saying, of course. I mean, that we must comply with both state and federal law, yes.
And, Mr. Chair, and you would agree that under the Voting Rights Act that federal observers and monitors under certain circumstances can be required for certain states and for certain polling locations, and that their job under the Voting Rights Act is to provide guidance for compliance with federal election law?
Mr. Chairman, I'd answer the gentlelady by saying absolutely. And that's where, when they're providing guidance and the election process is involved and election officials are involved and the election official checks with their boss and makes sure that everything's in compliance, then we're not going outside of federal or state law, that we're complying with it at every turn.
But, Mr. Chair.
Yes, ma'am.
But the way I read your bill, if a federal monitor or observer provides any such guidance, a local election official could not implement that guidance without permission from the Department of Elections, which I think is a violation of the Federal Voting Rights Act.
Mr. Chairman, this sets forth a protection. We've used the word guardrails in this committee today. This is setting forth guardrails. It's not meant to subvert the Voting Rights Act or any protectionary laws from the federal government that ensure that every single person who's eligible to vote can vote. That is not the purpose of this bill. This is the purpose to make sure that we maintain that Virginia elections are Virginia elections run by our department and comply with, wait for it, state and federal law in every regard, in every measure, at every turn.
Mr. Chair.
Yes, ma'am.
You're a good witness, so I know you're not going to agree with me, so I'm just going to make my closing argument. Mr. Chair.
You can try.
The way this bill is written, it would require where, federal election monitors aren't just appointed for certain places on a whim. It's usually because of some history, recent history about what's going on in that locality. And the way this bill is written, a local election official could not implement the guidance provided by federal election observers put in place under the Voting Rights Act because a history of discrimination or voter suppression or intimidation that has been found in that area, they could not implement their guidance without written permission from the department. And there have been times, and there could be times again, where the department does not grant that permission. And then you have a situation where a local election official is being required by state law to ultimately violate the Voting Rights Act. And I think we do not want to go down that path.
Senator Bell?
Thank you, Mr. Chairman. On line 15 of the bill, does it not say that any instrument of the federal government cannot be involved unless they receive written authorization from the department?
Mr. Chairman, I answer the gentleman by saying no. It doesn't say that they cannot be any instrument of the federal government cannot be involved. It is only triggered when they offer guidance with regard to voter registration or the administration of election. Then they fall into the same category as a civil society group, third party, someone who's not an agent of the Commonwealth. Then that election official reports that to the department. The department reviews and gives written permission to do it or tells them that's in violation of state or federal law.
Mr. Chairman?
Yes, sir.
The Federal Bureau of Investigation's a federal organization, has a public corruption unit which is charged with a limited role in ensuring fair and free elections. And part of these, their responsibilities, it becomes in their realm if a ballot of one or more federal candidates, a crime or allegation involves an election official who could be abusing their duties, fraudulent voter registration and or voters who are believed not to be U.S. citizens. My read of this would impede their involvement in investigation and perhaps stand in the way of a speedy resolution. What is your response? Because it seems like this would put an automatic level between the FBI doing their job.
Mr. Chairman, I would answer the gentleman by saying it does not do any such thing. None of this would impede a lawful criminal investigation on the state or federal level of any participant involving areas such as voter registration drives, or the administration of any election. To think so is, quite frankly, with all due respect to my good friend, Senator Bell, absurd. I think sometimes we read too much into things. It is not meant to keep federal agencies or state law enforcement from being able to investigate crimes. Now, usually when we're investigating crimes, Mr. Chairman, those are crimes that usually have just happened or happened in the past. One may think that the federal government has granted federal power to the FBI to be monitoring for contiguous crimes that are going on at that moment. I'd find it hard to feel or to find that would ever happen. But I can tell you that this is just when an election official receives from a third party some guidance. Check with your boss. And if your boss says it's okay, then do it. If your boss says it doesn't okay, then don't do it. And your boss better know federal and state election law, or they shouldn't be your boss.
Mr. Chair, I have a motion.
Please.
Wait a minute. Let me do my job. Anyone in the audience in support of this bill? Anyone in the audience against this bill?
There's one speaker on Zoom, Mr.
Yes,
Chairman.
ma'am. Hit that one speaker, then I had the motion again.
Stuart Whitson, please unmute and provide your testimony now.
Mr. Chairman, members of the committee, my name is Stu Whitson, and I'm a visiting fellow at Opportunity Solutions Project. I'm also a proud citizen of Virginia. OSP is a nonprofit, nonpartisan advocacy organization dedicated to advancing policies that promote that reduce barriers to work and that promote free and fair elections that inspire voter confidence. I'm submitting this testimony in support of SB 1516. Look, this is a straightforward nonpartisan bill that seeks to answer two questions. First, does it make sense to require election officials who are unclear about how to properly carry out the election laws passed by our General Assembly to turn to election authorities of our Commonwealth to find the answer, rather than relying on guidance from third-party groups or others? And second, Does it also make sense for the state to be made aware anytime a group provides such guidance to our election officials so that we can maintain proper oversight? This bill answers both of those questions with an emphatic yes.
Thank you so much, sir.
Two new requirements.
Thank you, sir. Thank you so much.
Thank you.
All right.
That
We
completes
heard
the speakers.
Now we're ready for a motion, please.
Substitute motion.
Yes, ma'am.
With love, I move that we PBI this bill.
Substitute motion with love to PBI the bill. Can that be put in the record? Open the roll, please.
Ayes 9, noes 5.
All right. Senator Surveyor, you next.
So, Mr. Chairman, let's go back to Senate Bill 1431, which was the recall bill that was heard in subcommittee and then sent out with no recommendation. So we heard testimony.
You don't have to repeat all this again, do we?
I got it. But at subcommittee, we did take testimony from Pia Trigiani, who was on the chairman of the subcommittee, and Boyd Graves that heard the bill. And the short version is this is trying to put in law what our law actually is, so that fewer of these recall petitions get filed for reasons that they shouldn't be. So it clarifies that you can file this for a clear ministerial duty violation, not just not a policy disagreement. Makes that clear. It makes clear what the petition verification process is. Right now, there's ambiguity about both the type of petition that's filed. People make their homemade petitions and they sign stuff, and this makes a clear, standardized form, and then it creates a process where the registrar verifies the forms, which is the process that is been used. And then it makes it clear the grounds for which the circuit court can dismiss a petition if it's not adequate. And then it makes clear what the burden of proof is in the legal proceeding. And there was also some amendments, Brooks, and I would, during the drafting process, it got noted that one of the things Boyd Graves missed that we need to deal with is it doesn't say if the Commonwealth Attorney is the subject of the recall petition, whether they get to review their own recall petition or whether they have to, we bring in somebody else. And so the amendment we suggested was that if the recall petition is against the Commonwealth Attorney, that the Supreme Court would appoint an independent Commonwealth Attorney to evaluate the sufficiency of that petition. So I'd move that amendment. Do you have that, Brooks?
Been properly moved, second. Move the amendment. All in favor, use the sign saying aye.
Aye.
All opposed, ayes have it. Thank you.
I think there was one other thing in that amendment, right?
Yeah, Mr. Chairman.
Yes.
There were two amendments in the subcommittee. The first one was on line 84 of the introduced bill after petition. Insert, if the subject of the petition is the attorney for the Commonwealth, the Chief Justice of the Supreme Court of Virginia shall appoint an alternate attorney for the Commonwealth to receive the copy of the petition. And then the second amendment was on line 93 of the introduced bill after officer, insert, pursuant to section 24.2-233.
Right, and I would move the second amendment.
Been properly moved, second amendment. All in favor, use the sign saying aye.
Aye.
All opposed, thank you.
And that second one just makes it clear that the Commonwealth Attorney is to judge the grounds for the recall against the standards in the statute and not whatever standards the Commonwealth Attorney feels like using. So that's basically what that amendment does. But again, this bill is just an attempt to codify a whole bunch of Supreme Court cases so we see fewer of these petitions getting filed because people are confused. Mr. Chairman, having said that, I would move the bill to be reported.
The properly moved, second, report the bill. I'm sorry. Do we have anyone in the audience?
I don't. We already took public testimony, and the bill hasn't changed since we were in subcommittee, so I don't think we need more public testimony.
I agree with you. Open the roll, please.
Ayes 13, no 0, 1 abstention.
No 0, 1 abstention. Thank you. The bill has been approved. What we got? Senator Mason. We done that 15-14 yet? No. Senator Mason, and we got two left, I believe. Senator Mason and SJ 224, Senator Chase. Then we will be done, I believe. Clerk.
And Mr. Chairman, I have texted Senator Chase 3 times trying to tell her that she left with a bill still on the docket, and I have not heard back from her. Asked her if
Can
she's
anyone
coming
take
back.
up Senator Mason bill? We'll give them 5 minutes. Not we can get out of here. You're lucky, Doc. You're lucky, Doc. You have 5 minutes. You have 5
Chairman,
minutes.
you call and I answer.
Okay.
With Senate Bill 1514.
Yes, sir.
Oh, I should be in a little better shape than I am, Mr. Chairman. So, Mr. Chairman, this is a bill that passed both chambers of the General Assembly in the last administration and then was vetoed because it gave the appearance, I guess, that it was targeting or going after a particular group, and not at all. It's really a protection mechanism for both registrars and the local board of elections that gives the registrar an opportunity to appeal to the circuit court if they're fired. Now, and have a hearing as to what went down. This has nothing to do with the change of control politically of the local electoral board. They get to select whomever they select, but throughout the normal course of business, the local board recognizes that if in fact they are going to fire someone, that the registrar has the opportunity to appeal to circuit court, so they should do it and will do it for legitimate purposes and reasons. And it gives the registrar something that today they don't have, and that's the chance to say, what did I do wrong? I've just been serving the people, and I don't believe that I've been fired with cause, and have a court hear it. That's the bill, Mr.
All right. Question from the committee?
Mr. Chairman.
Yes, sir.
In working on I have a question for council. So in working on the bill we just reported a moment ago, Brooks had identified a potential conflict I thought he might want to raise for the committee with this bill.
Okay, sorry.
Right, Mr. Chairman, it's not so much a problem with this bill as under the other bill we just heard, Senator Saravel's bill.
I thought it was this one.
No, it's your sorry if I was unclear about that. But in section 235, where the procedures are, under Senator Saravel's bill, it presumes that section is only for petitions that are received pursuant to section 233, but section 234 of current code also allows the registrar to use those procedures, but there is no petition. Under Senator Saravel's bill, it says the registrar receives the petition, and then the registrar decides if the petition is valid. So we might want to clean that one up just to make sure that the registrar isn't receiving a petition for their own removal.
Okay, so Brooks, what about this one? What about this one? I want to get this one done first.
I thought he was doing this on my mistake.
Okay, but let's get this out of the way first.
Mr. Chairman, I'm thoroughly confused.
Okay, I want you to be confused. My question is this. So, is there any concern about this bill? Not we can always go back to his bill, but this one. Are we good on this one? Any questions from the committee on this one? Any concern about this particular bill?
Sorry.
Any members in the audience who will support this bill, please come forward.
If anyone on Zoom would like to speak in support of this bill, please raise your hand electronically.
Sir, how you doing?
Fine, Mr. Chairman, members of the committee, David Bailey, on behalf of the Voter Registrars Association, we fully support the bill. We did previously, and we do again now. We feel that it gives transparency and it helps maintain integrity and tries to just remove another potential element of partisanship that can take place. So we fully support the bill and encourage you to report it.
Thank you so much, sir. Next, please. Anyone else present in support of the bill?
Yeah, no, they go.
We have one speaker on Zoom, Mr. Chairman.
Yes, please.
Allison Robbins, please unmute and provide your testimony now.
Thank you, Mr. Chairman. I'm Allison Robbins. I'm the Director of Elections and General Registrar for the County of Wise, and I'm the Legislative Chair for the Voter Registrars Association. Just to clear up the previous question, this only deals with the circumstance in which the State Board of Elections or the local electoral board file a motion in circuit court to remove a general registrar. There is no public petitioning process that registrars would have to review.
Thank you so much.
But we strongly support the bill. Thank you so much.
Thank you so much, ma'am. Any
That
more
completes the
petition?
speakers.
Anyone in opposition of the bill?
Mr. Chairman.
Wait a minute. Anyone in the Zoom opposition to the bill? Yes, sir.
Mr. Chairman, I just, again, kind of like I did with the other one, just want to make sure I clearly understand what the process is. So right now, electoral board members, the ones that are appointed by the circuit court, can apply to have a registrar removed, and then that goes through a process. We're changing that. We are changing that process, correct? So to be that the State Board of Elections has to be the ones that file that, not the local.
Mr. Chairman, Senator McDougal, line 105 still says a majority of the members of the local board. So it could be both. What we're saying is after that point, they can petition to the circuit court and be represented by an attorney to just say what happened. Well, why am I getting fired? That's the change.
So, Mr. Chairman, so you think the only real substantive change, in your opinion, is that an attorney can now represent them that the government is paying for?
I believe that to be the case, and maybe I'll ask
Ms.
Brooks to just make darn sure that's the case.
Can you hold off 1 minute? Ask that question.
Mr. Chairman, maybe I can ask, right now, under the law today, for a registrar to be removed, it has to be the majority of the local electoral board that files that petition. Under this bill, you can have that, or you could have the State Board of Elections. So you're adding in a different group of people that's not in the community that could file as well. Is that accurate?
Mr. Chairman, Senator McDougal, that's correct.
And Mr. Chairman, and today, it's the state board, majority of the State Board of Election that can file to have members of the local electoral board removed, and we're not changing that. Is that right?
Mr. Chairman, that's correct.
And then, Mr. Chairman, the only other change in this is now we have somebody from risk management. The government is paying an attorney for either electoral board or the registrar to defend that action?
Mr. Chairman, that's correct.
Are there any other differences that I missed? Okay.
Mr. Chairman, Senator McDougal, I think that's all.
You satisfied, sir? Another question? Any other question from the committee? Anyone in the audience in support? Anyone in support of 1514? Oh, we got that already, okay. The opposition, okay, done. All right.
Mr. Chair.
Yes, ma'am.
Move to report.
Been proper moving, second report. Open the roll, please. I got it. Okay, yes.
Someone can get you. They got you. Ayes 13, no 0.
Thank you so much. Thank you, sir. All right. I'm saying, I was trying to track you down. You left me. Ain't it? What we got, sir?
Mr. Chairman, I told you the bill was dead if he didn't come back. It might be the same way if he's here.
The same thing, Senator McDougal. I've got Senate Bill 1427.
What's that now?
Senate Bill 1427.
1427, yes, sir.
And what I'd like to do is I'd like to amend it so that on line 13 where it says any expenditure, it would say any expenditure or contribution. And then on line 15 where it says any single expenditure of, it would say any single expenditure or contribution of. And then on line 16 where it says such expenditure.
Hold on for a minute. Do you have this? Do you have these amendments or change? You have them? You doing them now? You don't have them nowhere?
It says every time the word expenditure appears, it would say or contribution.
Brooks, you got this, please? Let's get it down. You cost my lawyer to work. You should have this in writing already when you got here.
1527.
Okay, now start again, please, sir, if you don't mind. You mind starting again?
Oh, yes, sir. On line 13, it would say any contribution or expenditure, where it currently says any expenditure. On 15, where it says any single expenditure, it would say any single contribution or expenditure. On 16, where it says such expenditure, it would say such contribution or expenditure.
I'm going too fast because he's writing what you're doing.
Mr. Chairman,
Yes,
question
sir.
at the appropriate time.
Well, yes, sir. Wait a minute. Let's get these changes in first. 13, 15, and 16, Bruce.
And then on 18 and 19 as well. Each time it says expenditure, it would say contribution or expenditure.
Got him? Okay. Is that a motion? Is there a motion by somebody on that? Proper moving seconds, these changes, all in favor, use sign saying aye? I'll have, okay, now, sir.
Thank you, Chairman Spruill. What the bill does with those amendments is it requires whenever there are substantial expenditures or contributions in PACs, basically in the final month of the campaign, October 1 going forward, they would have to be reported quickly within the 24-hour reports.
Mr. Chairman.
Wait a minute. I believe Mr. Bell had asked first. Is that right, Mr. Bell?
Yeah, he
Yes,
did.
sir. All right.
Thank you, Mr. Chairman. First question, what is the penalty for not doing this?
It follows the same other failures to follow the reporting requirements elsewhere in the code. It doesn't have an enhanced penalty. It's the exact same.
Mr. Chairman,
Yes,
follow up
sir.
on that question.
Mm-hmm.
So would that, I believe it's what, a $250 fine, would it be for each item not reported or per day?
I believe there's a multiplier. I think council could probably, because I know if you continue to fail to abide by our reporting rules, it adds up quicker.
Okay. Ms. Senator Seville?
And
Mr. Chairman? So I got a question for the patron. So this basically just puts PACs and campaign committees on the pretty much on level ground, right? I mean, it says that PACs have to. Okay, not on expenditure, but at least on contributions, it says the PACs have to report just like campaigns do. And I understand that you're also adding expenditures to that for large ones, right? That's basically what this does.
that's the general thought. So a concern that I have, and I fear that we're going to experience it a lot this fall, is, and it's happening in other states, is, and it happened in the last governor's race as well, new PACs that were previously unfamiliar with originate in late summer, and all of a sudden they start playing significantly. And this has happened in several other states, in several legislative races. We haven't seen it happen in legislative races yet, but I suspect it's likely going to happen this year. And no one knows until after the election who it was. So you have situations in some states where you'll have in Republican or Democratic primaries highly ideological ads being run, suggesting that someone is not actually, sufficiently progressive or sufficiently conservative. And it's kind of curious to a lot of observers, but a lot more money is being spent in the PAC than is being spent by the actual campaigns. And then afterwards, it's found out that it might be, or well, in these cases, it was industry interest that had no concern about ideology, and that's similar to what happened in the governor's race as well. So I just think that it's important that we know who's funding these things. What we do with our campaigns, what our opponents do with their campaigns, that's visible, and we have requirements that we stand by our ad. But
Sir,
what we have going, yes, sir.
Wait a minute. So you're talking about PACs, right?
Yes, sir.
Okay. Now, so have you asked, so I'm trying, you answer somebody's question. I'm trying to get to answer the question so we can move on. And you just, so
Mr. Chairman.
Wait a minute, so have you answered the question? Because I want to answer the question so we can move on.
Yes,
ma'am.
sir.
Go ahead.
Thank you, Mr. Chair. So currently, the way it is now is a PAC doesn't have to report for possibly even months later. And your effort here is to make sure that there is some visibility so that if Moms for Good Government who are not really a group of moms, but perhaps are another group. We've just passed a law. We've just passed a piece of legislation that says you have to put the names of the top 3 donors of a PAC, right? And this would then say those Moms of Good Government are buying a TV ad or doing a big mail drop or something like that. Is that what your hope is in getting this information so that we know that that's happening?
Mr. Chairman, I would tell the senator, yeah, that's the idea. I focused on the November election in part because I'm not going to be able to get it to go into effect before the primaries. But what's happened in several other states, the gubernatorial race, that was in the general election, where an industry came in with highly ideological advertising that's probably not actually related to what their interests are. No one before or since has believed that's what their interests were. In these primaries, they're highly ideological advertising. And so, it would make sense to also include the final 30 days of a primary as well. But I think you understand what I'm trying to get at. So if you like the concept, I'm happy to spend more time with you. If you all don't like the concept, I
appreciate it, but we ain't got a whole lot of time to spend. I appreciate that. Any other question from the committee? Any other question from the committee?
Mr. Chairman.
Yes, sir.
Just to clarify, an in-kind donation would also be considered of any service as part of this expenditure.
Mr. Chairman, yes, sir.
Is that in-kind from the PAC?
Yes,
Any
sir.
in-kind?
From the PAC.
And Mr. Chairman, one follow-on.
Wait a minute. I want my question answered. Even in-kind, we're talking from the PAC as well, right? Okay, not the regular, just from the PAC.
I'm sorry, Mr. Chairman, I heard not from something else. It's
No, sir.
The PAC is only the ones that are envisioned in this bill.
Okay, all right.
And that's the larger concept I'm trying to work on.
Yes, sir.
Mr. Chairman, thank you. The other question I had is candidates report these large donations, what is it, 14 days prior to the election, 2 weeks out, to make sure I got that right? And I was wondering why you did it a month, a little over a month out, 5 weeks out. Why you didn't align with the other one?
Mr. Chairman, I'm happy to talk about different timelines, but I actually think the PACs need to be further out because they won't have any reporting.
Thank you so much.
Mr. Chairman. Until after the election.
Wait a minute. Okay. You do, Mr. Bell? You do? Yes, sir.
Mr. Chairman, if I understand, PACs report on that first day of October. I guess they file the reports on like the 10th or the 15th. So there's no actual disclosure of their receipts unless they're greater than $10,000 from that October 1st date up till the election. Is that correct?
Yes, sir.
Another question from the members of the committee. Anyone in the audience in support?
We have one speaker on Zoom, Mr. Chairman.
And those who in support, please.
Deb Wake, League of Women Voters of Virginia. We support this bill. It provides voters with campaign finance information, particularly in the short time before elections.
Thank you so much. Anyone else in the audience in support? Anyone on Zoom in support?
Nancy Morgan, please unmute and provide your testimony now.
Thank you, Mr. Chair. I'm Nancy Morgan, coordinator of the nonpartisan group Big Money Out. We advocate on behalf of campaign finance reform. We'd like to thank Senator Suderland for this common sense disclosure recommendation. We wish the legislation also covered federal and out-of-state PACs, and they report to the federal elections, but this legislation moves us in the right direction. It also complements the bill that that you just moved out of committee from Barbara Favola. She dealt with disclosure of the top 3 donors, but she didn't address the timing of it. So 90% of Virginians want total full disclosure, and it bills like this, which provide transparency on who's trying to influence our election, that builds trust in government. So thank you very much, Mr. Chair.
Thank you so much, ma'am. Anyone else in support?
That completes the speakers, Mr.
Right.
Chairman.
Anyone in opposition of the bill? One time. Anyone in opposition? 2 times. Well, now, are there any more questions?
Mr. Chair, move to report.
It's been properly moved and a second that we report this fine bill from Sewer Line. I'm hoping you will vote for your own bill on the floor.
I will try.
Bless your heart. Open the floor. Open it up, please.
Ayes 12, no 0, 1 abstention.
Thank you, Mr. Chairman.
You're so welcome. All right. Who we got left? Senator Chase, you up? You tried to call you.
Thank you. I've got 4 other bills on the other committee, so
Okay.
it's like, I'll be very quick on this. This is
Yes,
a
ma'am.
bill that I present every year as it relates to term limits. And it's basically, in a nutshell, it's 12 years in the House, 12 years in the Senate, total of 24 years in the General Assembly. The objective here is to eliminate career politicians, folks that have been here 24 years and longer. You know, we appreciate their service, but it's time to go back and go back home and allow new, fresh blood to come into the General Assembly. And we want to ensure that our elected representatives represent the people. And so that's why I continue to introduce this bill. There are other states who have implemented term limits, including Florida, Louisiana, Missouri. There's 12 other states. I won't go through all of those. Virginia has a tradition of having a citizen legislature. We should be promoting the temporary nature of elected positions rather than creating careers out of holding office. We should go back to our families and businesses in the community after we have served our allotted terms and subject to the laws that we implement. And that is the bill.
Thank you. Members of the committee, any comments from members of the committee?
It's a good bill.
Bless your heart. Anyone present want to speak in favor of the bill?
Those on Zoom who would like to speak in support of this bill, please raise your hand electronically.
Anyone in the Zoom want to speak in favor of the bill?
We have 1 speaker, Mr. Chairman.
In favor?
Yes.
Yes, ma'am.
Vic Nichols, once your screen loads, please unmute and provide your testimony. She's not. Oh, she just loaded.
All right. Anyone in opposition of the bill in the audience? Anyone in opposition? Anyone in Zoom in opposition? Last time, anyone in the...
We had a speaker, but her screen didn't load, Mr. Chairman. There are no more speakers.
Thank you so much.
Mr. Chairman.
Yes, sir.
Thank you, Mr. Chairman. I move to PB out of the bill and speak to that motion.
Yes, sir.
Is there a second? I'm looking at VPAP right now, and according to VPAP, only 15% of the entire General Assembly has served longer than 20 years. It's actually looks like about 60, 70, 65% has served less than 12. The House and the Senate are a little different, but there's been a lot of turnover in the legislature over the last 14 years that I've served, and I sort of feel like even though we don't have term limits, we kind of have a lot of turnover. And
There's still quite a few people in leadership who've been here more than 24 years. Though.
There's, Saslow was, here with...
All right, let's go. Wait a minute.
Excluding the chair.
Don't talk about Saslow. He's been around since George Washington. Leave him alone.
I was thinking of King George. I mean, before that, but... Anyway, Mr. Chairman, I just don't see it as necessary I hope we sustain my motion.
We have a motion and a second to PBI. Any other question? Open the roll, please. Thank you so much, ma'am.
Thank you, Mr. Chairman.
Who got how?
Ayes 10, no 0, 3 abstentions. Nobody.
Who is how?
Nobody.
Okay. All right, thank you. Anything else we got?
We're done for crossover.
So we're done for crossover. To committees, thank you all so much for allowing me to serve y'all for my first term as chairperson. I know I was a pain to some of y'all, but thank you anyway, and I love y'all.
Bless your heart.